Good evening, everyone. Mr. Arjun Ram Meghwal, Honorable Minister of State, Independent Charge, Law and Justice, Honorable Acting Chief Justice, Justice Manmohan, Mr. Mohit Mathur, Senior Advocate, Member Parliament, Rajya Sabha, Mr. Chetan Sharma, Senior Advocate and the learned Additional Solicitor General, and for me an elder brother, Mr. Vikrant Yadav, Honorary Secretary, Supreme Court Bar Association, Mr. Surendra Gupta and Mr. Neeraj of Lawyers Voice, Senior Advocates, members of the bar, my young friends, ladies and gentlemen. The topic suggested today was for the new laws from the colonial era emerging into the new India. As the topic suggests, we must, as advocates, also look at the intention, as we are told, while interpreting any statutes, the intent of the legislature while enacting the statute. The intention of the legislature and the work carried out to draft these is laudable, undoubtedly, because they've gone into a lot of efforts, a lot of aspects which had to be given a go by and adapt ourselves to what is the requirement of the day. And as Mr. Jethmalani rightly said, the changing scenarios had to be adapted. The stakeholders were taken into confidence. But sir, you have given one side of the coin, one's perspective. Yes, undoubtedly the statute as framed and as likely to be in force from 1st of July, for which most of us, at least on the criminal side, are going to utilize our vacations for this purpose. To understand it from 1st of July, we need to know. Forget BNS, forget IPC, learn BNS. So there will be no 420, it will be 318. So start learning the new numerals. Mr. Jethmalani has rightly taken us through and in detail some kind of a deterrence theory was added and looked into while introducing the punishments, because in 33 offences the punishments have been increased. For 83 offences the fine stands to be increased. But in all these cases, no criminal lawyer, I think, would have any objection, because most of them were those penal provisions which actually required to be made a little more stringent, looking into what the scenario today is. And fines of 100 rupees or 500 rupees actually doesn't serve the purpose. It's probably petty cash for many. So some kind of a deterrence is necessary when you are dealing with any penal statute. But what is more important is that we must understand that these statutes have been brought in, not just an old wine in a new bottle, but also with a theory of not a Dand Sanhita, but a Nyaya Sanhita. So the concept of Nyaya has been given a much higher platform and pedestal than what we generally learned in all these years of the penal statute. And why I say so is, what we used to see only by way of judicial activism and judicial pronouncements, today we have community service as an sentencing provision for 6 offences, and in some, for the first time offences, community service has been added. We can recall, till about last year, one of our honorable judges used to force us to concede to planting of trees. There have been occasions. Thank you, sir. Not at all. There had been occasions where the courts would ask teachers who are being penalized for any kind of an act of misdemeanor to do some remedial classes. So those kind of community services are a welcome change, undoubtedly. And as sir has taken us through different sections of removing of sedition and introducing of a concept of deshdroh, the mandatory minimum punishments have been increased in sentences, extraterritorial applications and all these things are there. But there is something which I want, because we are all students of law, and it will be our onus, as Mr. Gupta said in his welcome speech, that those who cannot access or knock the doors of justice, we have to be their voices. And when we have to be their voices, we have to also understand what the law provides for them, what the law safeguards for them, and what the law they are being penalized under. As students of law, please understand the statute starts with a preamble that it's a consolidating and amending act. And why I emphasize on this word consolidating, that all of us here understand that consolidating act means that you are assimilating all into one. But what Mahesh mentioned is perhaps not a safeguard when you ask the superintendent of police to decide whether he has to invoke UAPA or the BNS. I doubt any lawyer would accept a power given to a police officer to decide whether to invoke UAPA or BNS. And why I say so is, please understand that the legislature in its wisdom, while including it as an offense under Terrorist Act, the same definition into the BNS, has not altered your provisions of bail. The provisions of bail under 479 of BNSS, the Nagrik Suraksha Sanhita, does not have the twin conditions which are requisite for the UAPA Act to seek bail. So when I have a simpler system of bail under BNSS, the Bharatiya Nagrik Suraksha Sanhita, why should a superintendent of police be allowed to put me to a higher and a stricter test at his whim and fancy? Those guidelines are missing, and therefore we as students of law and as advocates and as champions of justice, we will need to take it up in our subsequent challenges and the cases to somehow get judicial verdicts on drawing guidelines what are absent. So those missing links we'll have to fill in when we understand the challenges that are posed. Similarly, organized crime, which Mr. Jethmalani mentioned, is being included in 111. There is a section 112 also in Bharatiya Nyaya Sanhita, which says petty organized crime. Now I ask myself, what we have learned is jo pakda gaya wo chor. And in police stations we would have 10 cases foisted on one person. As soon as we get one thief caught, all the unclaimed cases, all unsolved cases would be foisted on him. So we have now a higher degree. The legislature intended, and a very welcome thing, if you read BNSS, the Bharatiya Nagrik Suraksha Sanhita, it deals with gradation of sentencing. It deals with first time offences. First time sentencing is on a lesser grade. And the second offender, or repeat offender as we call it, would be punishable with a higher sentence. But if you include petty organized crime as an offense, then these petty criminals will also be roped in. That's where we have to step in. And I always say, the statutes may be having something lacking, but we should not be lacking in our efforts. So when we have cases, and another welcome change, which due to paucity of time Mr. Jethmalani perhaps missed, is the offense of mob lynching and deaths caused by mob lynching into section 103 of murder itself. The clause 2 of murder 103 actually includes offenses being committed by these mobs, and the hatred which generally we as defense counsels are guilty of is we try to justify it as this is lack of motive. So since there is no motive, no animus to kill this person, how am I liable under murder? So we get away with it and get it reduced to a culpable homicide. But fortunately, this gap was filled by adding this section and allowing the hate crimes to be covered as murder itself. Now, there are certain streamlinings done, and since we are here only for a brief period, we can't keep on going with this debate. Something which Delhi has to get used to is there will be no MMs now, no metropolitan magistrates. All over the country, the nomenclature of the judges in the district judiciary will be the judicial magistrate second class, judicial magistrate first class, sessions judges and executive magistrates. So let's get used to having our officers as judicial magistrates first class, the chief judicial magistrates, CJMs, ACJMs, etc. Now, one good provision, which was otherwise a judge-made law, was a zero FIR concept. Now, this zero FIR, though introduced in section 173, which used to be 154 of the current CRPC, in the Bharatiya Nagarik Suraksha Sanhita is section 173. What it permits is whether the ilaka has the jurisdiction or not, yet an FIR can be registered. Till now, what we have learned from the judicial pronouncements is if there is a zero FIR registered, it will be then sent to the concerned jurisdiction. Immediately on recording, you record the FIR, term it as a zero FIR and send it to the concerned jurisdiction. Unfortunately, it skipped the attention of the lawmakers, or the section has been added in such a fashion that it allows even arrests to take place in places without jurisdiction, statements to be recorded, and even confessions to be recorded, and even 164 statements to be recorded in places without jurisdiction. All that is left is that at the stage of trial, it will be sent. Now, this is a place where we'll face a lot of challenges. The case parties are in Delhi, somewhere in Hyderabad, Kolkata, or other places. The man has contacts and he gets his FIR registered. He'll call, get the person summoned there, but to the police, because police has the powers to investigate. He can be arrested by the police without jurisdiction because they are permitted to do so. The magistrate, though doesn't have the power to take trial, but has the power to record a statement, deal with his arrest. Now this is a grey area. Lawyers here will have to develop this law, and lawyers across the country will have to deal with this, and our honorable courts will have to see that this is least misused by the agencies. We cannot allow the agencies to run amok. Gender neutrality and videography is something which is actually very necessary, because again, we people are guilty when we tell our clients कि घर पे किसी मेल मेंबर को मत छोड़ना, सर्विस नहीं हो सकती. If the person is not there, only a male member can take this service, but not anymore. Now, the service of summons is gender neutral. So even if there is a lady there in the house, she can be served with the summons, which I think will help reduce the time that is lost in doing the basic things. Again, something good that has happened is in what used to be 156(3), getting an FIR registered by going to the magistrate after complying with the first complaint to the SHO and then going to the superintendent of police under 154(3). The new section 173(4) says that if you have gone to these two levels and you come to the court for seeking directions for registration of an FIR, he will ask the person concerned also. The proposed accused will also get an opportunity. This is something which is necessary because this 156(3) misuse has been deprecated in a number of judgments, including Priyanka Srivastav recent judgments where they've said asking for affidavits. And this also helps because the section 173 today allows that for public servants, they have another additional safeguard that instead of a sanction at the time of cognizance, their superior officers will need to give an approval at the time of institution of the case itself. So that's a very welcome thing, but as a defense lawyer, I always say that bureaucrats drafting the law wanted to first protect themselves, so the public servants ensured that they are saved, the others may suffer. But something which as defense counsels we always feel and we are most affected with is bail applications. Now please read the new section 482, which is of anticipatory bail, no more for quashing. The BNSS section 482 for anticipatory bail has made it a tad bit higher test for going for anticipatory bail. It says now you have to show reason to believe, not a mere apprehension of arrest. So while drafting, please be careful. Instead of using the words that I apprehend arrest, it just might get dismissed. So please start using the word and get used to using the word, I have a reason to believe that I'll be arrested. Whether that suffices the judge or not, I can't say. Time will tell. But you will need to start using it in your language. You will need to start using it in your delivery to the judge and convince him that your reason is a very valid reason to believe. The last thing which I always felt in these statutes, you will need to understand it and challenge it, use it, is on the point of retrospectivity. Time is too short. I can discuss it at any point of time. It's a very interesting thing. If an offense starts on 29th of June and ends on 2nd of July, what will happen to me? Because BNSS protects proceedings initiated. BNS protects offenses which have been committed, and if you have suffered those offenses prior to the BNS coming into force, you will come in, you can still invoke the jurisdiction, but which one? CRPC, BNSS, BNS or IPC? Now that's a homework for all of us. And with that, I'd say thank you very much to the organizers for allowing me to speak here. Thank you very much.